You take a different position with respect to assuming sovereign immunity in your brief. So could you comment on the argument that it could, could possibly or we should assume sovereign immunity?
So our position is kind of consistent with what Justice Kagan was referencing earlier. Usually when this court has assumed without deciding a question, it's because it doesn't have an effect on the end outcome. So I think it would be a little bit strange to assume that here if you take the view that we think is the correct view, the correct reading of the statute, which is that it clearly does not abrogate that immunity. And so I think it would be a little bit strange to not address the existence of the immunity in the first place. We think it's not necessary to try and avoid that question here when this court's precedents dating back for a century have already decided that Puerto Rico is entitled to that immunity. And so we think it's appropriate to address that question in the first instance.
Do you have a case in which a territory has been granted or been said to have had sovereign immunity in another sovereign's courts?
So I think that the closest case that we have on that score is the Emanuel case, and of course the court ended up holding that the territory had waived its immunity, and so it wasn't necessary to the outcome of that case, but the court certainly went into the discussion of sovereign immunity in that case, and it seems that the implication of that is that it applies equally in territorial court and in federal court.